Hi everyone, I'm Rajarajeshwari, a chartered accountant, cost accountant, and a company secretary. And in today's topic, we will be learning about management and administration. So you were asking me about the weightage of the marks. So it is acceptance of deposits, registration of charges, and management and administration. Put together, it is 20 to 30%. That is the weightage of marks for this particular chapter. Is so what we are going to learn in this management and administration that we proceed. Any company, if it has started the business, it is managed by the directors, right? Who are the owners? The owners are the shareholders. Now, the shareholders have invested their money into the company. Say if it is ABC company, they have invested their money and the management has been entrusted with the directors of the company. So the directors take decision in their meetings, in their board meetings. Certain decisions can be taken by the directors themselves. Certain decisions can be taken only with the approval of the shareholders. So, what they will do is that they will ask the approval of the shareholders in the general meeting, in the annual general meeting. So, a company should have to hold at least once in a year an annual general meeting. It will meet and the shareholders and the company, that's why it's called as annual general meeting. It will be generally held at the registered office. Nowadays, there is a thing you can also attend the meeting and you can give your consent through postal ballot also. So, generally, it will be conducted once in a year, and the shareholders should have to give their approval. So, certain business will be there, mandatory business will be conducted. So, for any company, they will adopt the accounts and the appointment of auditors or declaration of dividend or appointment of directors retiring by rotation. So, these business will be ordinary business in the agenda, and anything other than these four, that is called as the special business, for which shareholders consent should have to be obtained. Now shareholders consent, if I say, it could be by way of an ordinary resolution or it could be by way of special resolution. So this we will be dealing with when we come across this resolution. So a meeting will be held, a resolution will be taken, whether they consent in favor or against, and whatever business has been transacted, that should be recorded. That it is recorded in the minutes book. You maintain a minutes book of both board meeting and the AGM. Or even if there is a general meeting, EGM, even there you hold the meeting, you pass the resolution, and you record the resolution in the minutes book maintained for this purpose. Once the meeting has been conducted, now AGM has been held, then the company should have to file certain returns, mandatory returns with the RBOs. What are they? They have to file the balance sheet and they have to file the annual return with the RBOC. So that we will be seeing in annual return. Even if no special business has been transacted, these two returns has to be filed every year with the RBOC. Now, is that all? No. The company should also maintain a statutory register. What is a statutory? Statutory means it is compulsory, mandatory, it should have to be maintained. So that register should also be maintained by the company say like a register of members, register of debenture holders, director shareholding or foreign register, register of charges. All these things will be maintained by the company. So this is how it runs. So we will be dealing in today's session one by one, right? So the shareholders are the owners and they have the board manages the day-to-day affairs and it is exercised in their board meetings. Shareholders approval is obtained in the general meetings that will be recorded. And the general meetings, that is the focal point for the shareholders to specify their views and they can decide even if the dividend has been declared final dividend that should have to be approved by the shareholders. And the decision taken are recorded in the minutes book maintained. If it is a board meeting, in board meeting minutes, board meeting, they maintain separately board meeting minutes. If it is a general meeting, so it will be in the general meeting minutes. And at the conclusion of AGM, the company is required to prepare the annual return and file a copy thereof with the jurisdictional registrar of companies. Jurisdictional registrar of companies means if the company is in Mumbai, registered office is in Mumbai, then Mumbai ROC. If it is in Karnataka, depending on the state where which ROC comes, so in to that respective ROC, suppose if there is more than one ROC, which ROC jurisdiction this company location is there, that ROC you should have to file. So the respective ROC you should have to file the documents. Now, what we are going to learn in this? So, first we will be learning the registers. What are all the statutory registers and what is there? You have a register of members, you have a register of debenture holders, you have a foreign register. So, all those registers we will be dealing with under the registers. It is a mandatory requirement. Mandatory means compulsory. Every company should have to maintain a statutory register and wherein entries should be recorded within 7 days of the event taking place. So that they should have to maintain it in that register. And in this topic, we will also be learning about the annual return, what are the details that you will fill, then what are the requisites for convening a meeting, whether it is a board meeting, general meeting, what are all the requisites, then what is the meeting, how it is held, when the notice should have to be given. So all these details we will be learning in this topic. Now, going to the registers. What are the different types of registers that you should have to maintain? Now, you have a register of members. Who is a member? A member is a person, even if the company doesn't have a share capital, then still register of members should have to be maintained. So register of members, the moment he enters, he invests as money or he becomes a shareholder or even if there is no share capital, he is a member by specifying his name or you call it as subscribers to the memorandum. So initially at the time of incorporation, he would have subscribed his names to the memorandum. So subscribers to the memorandum. Then subsequently, when allotment is made, then he becomes a subsequent allotment is made. So if a person sees the memorandum of association, the last page, you would have learnt in that incorporation, who are all the subscribers to the memorandum. In case of private limited company, at least minimum 2 members are there. In case of public limited company, at least 7 members should be there. So they are the subscribers to the memorandum. So the moment the company is incorporated, within 7 days, they should have to incorporate these details. The format is Form MGT1, Management. So, in Form MGT1, On that basis, they should have to maintain this register. Then register of debenture holders. If the company has issued debentures, then it should be maintained in form MGT2, giving the details, how many debentures he has held, the name, address, and so on. Then when there are so many numbers, say if it is 5,000 members are there, then it is very voluminous. So the law suggests that if the number of members is more than 50, you should have to maintain an index of members also. For easy thing. If it is a small booklet, okay, it is fine. Suppose if your booklet is voluminous, what you do, you have an index in the beginning, right? So that you can locate it correctly. So like that, for register of members also, there should be an index of names of members. And you have to maintain the foreign register also. That foreign registers are maintained in MGT3 format. Now, even if there is a beneficial interest in any share, still they should have to maintain that details in that register. That register is MGT5 and MGT6. We will be learning in detail. And when they can close the register of members and what is the procedure of closing the register of members, how many days they can close maximum, those details we will be learning in this topic. Now, to get a clarity, subsection 1, section 88, subsection 1 talks about register of members, then register of debenture holders and register of other security holders. So, register of members, debenture holders, and other security holders. That is specified in subsection 1. Subsection 2 specifies that register to have an index of names if the number is more than 50, or if the uh, names is more than 50, you should have to have an index. Otherwise, it is optional. It's not mandatory. Then beneficial owners, that has been specified in subsection 3. And subsection 4 and rule 7 talks about foreign register and penalty if you don't maintain that register. What is the penalty provisions or penal provisions that the company is liable to pay has been specified in subsection 5. Now, what is this register of members? When I say register of members, you have got an equity share capital. In the liability side, you have got an equity share capital. And the company may also have a preference share capital, meaning you have members' equity shares and you have also issued preference shares. There will be different classes of shares also issued. So for all those details which is there, the company should have to maintain for each class of shares, holding each class of equity shares and preference shares of each member, the details. Now, what is that share capital? Now, he is having the share capital. Suppose A would have issued or A would have subscribed for 100 shares. Then B would have got 1000 shares. C would have got 5000 shares. Right? Now, this is an asset for that person. The earlier when we were maintaining physically, we used to write the distinctive numbers. It could be 101 to 200. This distinctive numbers could be 5001 to 6000. So this you call it as the distinctive numbers. Which number, what is a share certificate? That numbers. Now these details will be entered in the register. Now, this is the asset. The amount he has invested is his asset. So, for that, he will be given a share certificate that denotes that he is the holder of the asset. And those distinctive numbers will be written in the register of members. Probably his name, his address, Now, every details, now you have this email ID and other details should also be written. So whether he is residing in or outside India. So even if it is a foreigner, his details should also be entered there. And register of debenture holders and any security holders. That also you should have to give the details, maintain the details in the register. Now, every company limited by share shall, from the date of its registration, maintain a register of members. That is an MGT. One, they should, in that format, they should have to maintain. That format has been specified in MGT 1. What are all the details that you should have to write if the company does not have a share capital? Then you will write the name of the member, address of the member, email address. Suppose if it is a body corporate, then registered office address that you should have to write. Then PAN, if it is an individual or if it is a company, PAN of the company and corporate identity number. See, what is a corporate identity number, SIN number or CAN we call it as. For every company, there is a corporate identity number which specifies the year of registration and the place of registration. Suppose it is DL, it is Delhi registration. So if it is specified as 1980, so this is the year of registration. And the last five or six digits, that is your registration number in the certificate of incorporation. So this will specify the certificate or the corporate identity number will specify the place of registration, whether it is a private limited company or a public limited company, whether it is a private or public limited company. So every details will be specified on seeing the SIN itself or corporate identity number. A person can come to the conclusion. Then what is his nationality? That details should also be specified. Suppose a person is a minor. The rule says a minor is not competent to enter into a contract. So a minor's name can be entered along with the name of the guardian. The act is very strict because a minor as such cannot enter into a contract. He is not competent to enter into a contract. When the guardian's name is also specified along with the guardian's name, yes, the member, a minor's name can be entered, but guardian's name should also be entered. So that is the and date in which he became a member. Now A has got 100 shares. Now he has transferred it to B, this 100 shares. Now B becomes the member. Say if he has transferred it on 30th March 2026. Now B becomes the member only on the date on which he has received it. So on 30/3/2026 only he becomes the member. So only the date of becoming the member or the person has subscribed to the shares, has got the shares allotted. Then when is the date of allotment? That date you can write it. So date in which he became the member. Either he could have become the member by transfer of shares or transmission of shares. Both is covered here. Transfer means transmission means on the death of the person, if legal heirs will be, it will go to the shares, will go to the legal heir. So that you call it as transmission. Transfer means voluntary transfer from one person to another. So the date of becoming the member, what is the reason on what basis he became the member? That should be specified. Then date of cessation, when he ceases to be a member, that should also be specified. And the amount of guarantee if he has given. But here, if I'm talking about, anyway, for your understanding, I gave you, it is for companies not having share capital, I'm saying. Even for companies having share capital, this rule holds good. Then if it is any guarantee, if he has given, that amount of guarantee should also be written in that register. Any specific instructions which he has given, that also should have to be entered in the register. Then, for debenture holders, you have to maintain a separate register in form MGT2. So every company, so you have to read this correctly. Every company which what it does, this is every company who should have to maintain this register, every company should have to. When it should have to maintain, what is the event which forces them to maintain, which issues or allots debentures or any other security shall maintain a separate register. You have to maintain a separate register for register of debenture holders that you should have to maintain. Cessation means he ceases to be a member. He is no more a member. That is called as cessation. The joining as a member and this is cessation as a member. Date of cessation means he is no more a member. See, if a person dies, he is no more a member on that day. Or if he has transferred the shares, then he ceases to be a member. See, A has transferred the shares to B. So on 33/20/26, A will not be a member. He ceases to be a member. Instead, B will be the member. So for A ceases to be a member on 33 and B becomes a member on 33. That is the meaning. Date of cessation means he is no more a member, not a member. He is no more a member. Cessation, he was originally the member, but now he is not a member. So, which date he ceases to be a member? That is the date of cessation. Now, he shall, for debenture holders, every company who issues or allots debentures. So, when this event take place, then they should have to maintain a separate register. This wording is important. Maintain a register means not along with that register of members, you should have to write it. You have to maintain a separate register for debenture holders. For debenture holders or security holders, as the case may be. For each type of debentures. See, every type, they can issue a 9% debentures. Then after some other time, they may issue 12% debentures. So this is one category of debentures. This is another category of debentures. Type of debentures is different. So you have to maintain a separate register for each type of debentures or other securities. That is the meaning. So every word is important in that. In the examination, if they ask you write a note on maintenance of register of debenture holders, then you have to write each and every point. So how you should have to write it? You should have to practice writing it. Every company, when it should have to, which issues or allots debentures should have to maintain a separate register. These are the keywords that will be seen. Separate register for debenture holders for each type of debentures. For each type of debentures in form MGT. So each one is a point which students should have to note while reading itself. It's simply they say if you write it as every company should have to maintain a debenture in MGT2, the answer is not complete. You have to, while reading, you have to read each word in law and you should have to understand that. And once you understand, it will be easy for you to recollect it and write it in the examination. Then. Now, I said entries should have to be made in that register. Is there any time limit for it? Yes. So, within 7 days time period for making entries in the register, It is applicable to all the registers within 7 days of the date of approval by the board or committee. See, there is a shareholders committee or that will be a separate committee. So that committee can approve or the board can approve. Approving the allotment or transfer of shares, debentures or any securities. Now, the shareholder, I will tell you the impact of this. The shareholder have transferred the share. How will the company know about it? The company will know when it is intimated to the company by the shareholder. So then they will hold the board meeting and they will take the approval or they will make an approval for the transfer or transmission of shares or they will make a note of the transmission or in case of transfer they will give their approval. So from that day of approval within 7 days it should be entered in the register of members. The company should have to incorporate the details. That is the concept. So within 7 days of the date of approval by the board or the committee, it will be placed before the board. The board will take note of it in their board meeting. If there is any transfer of shares, transmission of shares, or if there is any allotment of shares, definitely on that day there will be a board meeting. So only then they can approve it. So if there is an allotment of shares, further allotment of shares, then subsequent allotment, some new members comes, XYZ become members. So these details should have to be entered within 7 days of the approval. Approving the allotment or transfer of shares or debentures or any other securities. Then the question is, this is what is the time period? Within what time it should have to be entered? Now here where the register should have to be maintained, where register needs to be maintained. Generally, we maintain it at the registered office of the company. Registered office of the company only, we maintain it. Majority of the companies will maintain it only at the registered office. But is there a way out? Can the company maintain the register at some other place other than the registered office? Comment if the question has been asked. There is an exception. If the company wants to maintain at the place other than the registered office, say a company has a registered office at one place and its
Hello, ma'am.
branch office at another place, it could be within the state or some other city not where it is located, it is at some other city.
Ma'am,
In Mumbai, the registered office is there. Suppose it wants to maintain at Pune office or some other office, it wants to maintain. So, if the company wants to maintain at other place within the city, town, or village in which the registered office is situated, or other place in India in which other place in India means it could be any place other than outside the registered office also, outside the state also it can maintain, provided there the condition is that 1/10 of the members entered in the register of members reside. So in that case also it can maintain it in that particular place. But it should have to pass a special resolution. It should have to pass a special resolution and then the company can maintain at the registered office. When I say special resolution, then it is shareholders' approval should have to be obtained. They will make this intention that they want to keep the register at place other than the registered office. They will pass the resolution in a general meeting that will be taken as a special business if it is an annual general meeting, because this is not an ordinary business. This is something not a routine business, that you call it as a special business. So you have to get the shareholders resolution. It is not an ordinary resolution. It is a special resolution. So the votes cast in favor of the resolution should be more than 3 times the vote cast against the resolution. I will deal it in detail when I come to this resolution, but ensure that it is a special resolution. So 3 points you should have to remember. First one, wait, just go through this. Okay. So now is the screen visible? Okay. So 3 points you should have to write it in the, if they ask you what are the exceptions, can the company maintain the register at some other place? It can maintain at the other place. Now, in this case, within the state in which the registered office is situated. So, other place within the city, town, or village in which the registered office is situated. That is first case. Then, in the second case, at any other place in India where more than 1/10 of the register of or the total members entered in the register reside. Suppose the office is in Mumbai. Majority of the persons are in Calcutta. So then they can maintain that in Kolkata. So that is the meaning. So any other, but what is the condition? More than 1/10 of the total members entered in the register of members reside. So in these two situations, it can be done provided you get the approval of the shareholders by convening a general meeting and passing it as a special resolution. So then it can be maintained. Then, shall we proceed further? Up to this, is this clear? Okay. Then, what are all the information that you should have to specify? Other information also to be referred in that register. The main information is that this is the other information that you should have to specify. Now, someone is asking, Madam, see, if the company has head office in Mumbai and opening a branch office in Punjab, then the registered office in Mumbai only. Suppose what is its registered office? If the registered office is in Mumbai, then ROC of Mumbai only will be considered. You can have a branches in all the states or in more than 10 states, but still where you have got it as a registered office, that is the jurisdictional registrar. See, in memorandum of association, you would have mentioned what is the registered office, right? In there is a 6 clauses in memorandum of association. You would have mentioned the name clause, then situation clause. The registered office will be situated in the state of Maharashtra. They would have mentioned. So when they have mentioned it in the memorandum, registered offices in the state of Maharashtra, then Mumbai ROC will be the jurisdictional ROC. They can have a branch office in Punjab, Haryana, Delhi, wherever they have it, but the registered office is in Mumbai only. So Mumbai ROC will be the jurisdictional registrar. So you have to file the documents only with Mumbai ROC because that is the place. In Maharashtra, you would have registered. Your SIN number will also be having that Maharashtra, right? So that will be there. Your number, year of incorporation, everything. That you cannot change it. You can change the registered office to Punjab. Then your jurisdictional ROC will become Punjab ROC. But till such case, when your office is there, your registrar is only Mumbai. Yes, yes. I will take the previous year question. Sure. Now, what is your doubt, Sridhar? Okay, ma'am. At the time, holding company is transfer the ROC. See, I will make this clear. The holding company, subsidiary company, whatever is the company, now the in memorandum of association, what is your situation of the registered office? If you have mentioned it as Mumbai, Mumbai ROC is your jurisdictional registrar. So that is the place where your registered office is situated. Can you change the registered office? Yes, you can change the registered office. You can transfer the office or you can change the registered office from Mumbai to Punjab, in which case it will be Punjab ROC will be your jurisdictional ROC. Once the registered office have been transferred, you have transferred the situation of the registered office, then it will be from Mumbai to Punjab. So that ROC will issue a fresh certificate of registration consequent to the change of registered office. So there the number will not be the same. The SIN number will not be the same because the files are getting transferred, right? So the number will not be the same. You will have a different corporate identity number. That is there. What are the other information that you should have to mention that we will see? If any order is passed by judicial or revenue authority or SEBI, SEBI will come in case of listed companies, right? Once when the shares are listed, SEBI is a regulatory authority, right? Or competent authority attaching the shares, debentures, or other securities. If an order is passed, that needs to be indicated in the respective register. If it is a shares or debentures, if it is a shares, you have to write it in register of members. If it is a debenture holders, you have to write it in debenture holders registration. Now, if it has given the directions, see, whenever a court or any judicial thing comes, you will get the word directions. Directions for when an order, all these are correlated words. Order, when an order is passed, you give the direction for remittance of dividend or interest. Dividend in case of, it could be preference shares, it could be ordinary shares, interest in case of debenture interest. The necessary reference of such order also you should have to make it in the register. All those details you should have to pass it in the register, write it in the register, mention it in the register. In case of companies whose securities are listed on a stock exchange in or outside India, if the company has made any pledge or charge or lien or hypothecation by the promoters. See, what they generally do is that promoters, for many company, they would have pledged their shares. They are the owners, they are the directors, they are the promoters, or they are the promoters, they are the owners. They would have pledged their shares and they would have obtained the loan on that basis. You should have to be careful when you invest in a thing whether the promoter's pledging is there or not. So that we used to see before investing. So created by the promoters, then in that case, the names of the pledgee or money or any revocation, everything should have to be entered in the register within 15 days of such an event. So 15 days, within 15 days of that event, it should be entered in the register. That is the concept. right? Then, if promoters, what is the other situation? If promoters of any listed company which has formed a joint venture company with another company have pledged or hypothecated or created a charge or lien in respect of the security, then in connection with that joint venture company, the particulars of pledge hypothecation shall be entered in the register of members within 15 days of the event. So here joint venture company, you call it as a joint venture company because if equal they have taken, they will form a joint venture agreement. Joint venture company means they would have formed a joint venture agreement and based on that they will do the business. So in that case, they have got equal rights with another company. So in case of a joint venture company with another company, if they have created all these if they have pledged or hypothecated or created a charge or lien, that too should have to be mentioned in the register of members. If they have pledged those shares and they have taken a loan or they have hypothecated, keeping this as a security, then it is a thing. For them, it is a current asset. Why? You can ask me how if it is the shares. See, for that person, it is a current asset, right? They have made an investment. You can make a share. You can make a loan. You can get a loan on the based on your investment also. That using those shares also you can get it. So for them, for that individual, it is a current asset. So they have this asset, they are pledging it and they are getting a loan that should also be entered in the register of members. That is the concept. Then if there is any change in status of members, if the person is no more, then those details should also be written. So whether it could be due to death or insolvency or there is a change in the name of a member or if it has been transferred to investor and education protection fund or any other reason. Then entries thereof explaining the change. See, this is very important. You are not supposed to simply write the entry alone, make the entry alone. Entries thereof explaining the change shall be made in the respective registers. Whether it could be a register of members or it could be register of debenture holders or other securities, you have to give the reason for the change. What is the explaining the change? That should have to be noted there in the register. That is the updating of change in the status of members. That should also be done. Then you have made an mistake or it needs to be corrected. So if any rectification is to be done pursuant to an order passed by the competent authority, then you have to make the necessary reference of such order that should be indicated in the respective register. So your answer is not complete if you simply write it as in the register. In the respective register means you have read it. So you are making known to the examiner that you have read the provisions correctly. So that is more important. So rectification of register pursuant to an order passed by whom? By the competent authority and the reference of that order should be indicated in the respective register. These 4 points are very important. Write a note on rectification of register. You have to write it this way. Then index of names. I said if the name or register of members is voluminous, then it will be easier if you have an index. It is not necessary if it is less than 50 members are there, you need not have an index. But once you have 100 members, 1000 members, it is better you should have a index of names. So every register maintained shall include an index of names included therein. However, the maintenance of index is not necessary when the number of members is less than 50. Suppose the company wants to maintain, it is optional. It can maintain. It can maintain. But the law says if it exceeds more than 50 members, then you should have to maintain the 50 or more. It is less than 50. So 50 or more, you should have to maintain the index. Then register and index of beneficial owners being maintained by the depository that is deemed to be the corresponding register. Now, when shares are held in demat form, the company generally do not maintain the register. It is held by the depository. So whatever they maintain, that is deemed to have been maintained by the company. So that is what this provision says. They would have maintained an index that is the deemed to be the corresponding register and index for the purpose of this act. Then foreign register. Now here the articles should have to authorize. Then if the articles authorize, then a separate register maintained in any country outside India. It could be Japan, it could be Malaysia, it could be USA, it could be any country outside India. A register maintained in any country outside India of foreign security holders, that is shares, debentures or other security holders or beneficial holders, to record the transaction. That is called as a foreign register. For this, the articles must authorize. It is optional to maintain. The law is silent. But if the articles specify, must authorize, if the articles authorized the company to maintain a foreign register, then the company can maintain. But once it maintains the register, then it should have to follow the rules. What is that? Other requirements relating to the foreign register, you should have to file the notice of the situation of the office where it is maintained. Then that should have to be intimated within 30 days of opening of the foreign register. Parallelly, you should also maintain one in India. Simultaneously, you are maintaining a foreign register in that particular country. So you should have to file with the ROC the notice of the situation of the office where such register is kept. And that notice should be filed in MGT3 with the requisite fee. So when you are maintaining the foreign register, you should have to intimate that ROC, yes, this company, ABC company, is maintaining a foreign register, say in Japan, it maintains. So that address, it should have to intimate it to the ROC. This is the place where the foreign register is maintained. That should be intimated within 30 days of opening of foreign register. Once you have, from the date of opening of the foreign register, you should have to file MGT3 specifying the situation of the office in which the register is kept with the jurisdictional ROC. But maintenance of foreign register is only optional. The articles should have to authorize that. Then, now you have started maintaining. Suppose you are going to discontinue maintaining the foreign register or you are not maintaining in that particular country. Then also you should have to maintain. So in case of any change, previously you were maintaining in Japan, now you are going to maintain in USA. So that is a change. You are not going to maintain. So the discontinuance of the foreign register, even then, you should have to mention that same with the ROC by filing Form MGT3. That too within 30 days of that discontinuance of the register or change of register. That you should have to do it. Then foreign register, it is part of the company's register. The main register is only the maintained in the registered office of the company. That is called as the principal register. That is foreign register is only an additional register. So principal register, that is a mandatory statutory register. You should have to maintain it. The format, it should be in the same format. Same format as that of the principal register. Then even inspection can be done by the any person that by any member of the foreign register. Inspection of foreign register can also be made. If the person wants to do an inspection, it can do it. Before closing the register, you should have to give in 2 newspapers circulating in the place where the foreign register is kept. That is the thing. So advertisement also should be given that the company is going to close the register. See, the formalities to be complied with is specified in the Act. So in at least 2 newspapers. At least means minimum 2. The wordings at least minimum 2 newspapers. That is the meaning of at least. Circulating in the place where the foreign register is kept. Then, in case of rectification, you are making the entries that can be done after the board records its approval. Then transmission of a copy of entry. Once you make a entry there in the foreign register, then within 15 days after the entry is made, you should have to transmit a copy of every entry made in that foreign register within 15 days. And you should have to duly update it. The principal register is also updated, foreign register is also updated. Once you make an entry, the principal register is also updated. And duplicate foreign register, it is only a duplicate. Main is at your registered office. Duplicate foreign register to be part of the principal register. Transactions should not be entered in any other register other than these. Now transfer of entries, now we are discontinuing that. That should have to be, if you are going to make that from one country to another country, you have to transfer that entries to other foreign register and as well as or to the principal register. You should have to make those entries. Transfer of entries, once you are going to discontinue that, you should have to transfer that entries to either to some other foreign register or to the principal register. You have to transfer all the entries. Suppose I make a failure in maintaining the register. The company has made a failure either to maintain the register or the authenticated, it should be authenticated. So failure to maintain register, that is a violation. The company is liable to a penalty of 3 lakhs. And every officer in default, definitely he also has to pay, but the company's penalty will be more than the individual. So every officer should have to pay a penalty of 50,000. And it is a compoundable offense. Compoundable means you can compound it by making an application. So it is compoundable under 441. Then authentication of entries. Authentication means you should have to sign. Who should have to sign the entries? When there is a company secretary, definitely he should have to sign that details, entries. Then any person authorized by the board, any other person. First preference to company secretary. When a company has appointed a company secretary, then it should be authenticated by the company secretary. When the company has no company secretary, then any other person authorized by the board to do it. He should have to affix his signature or he should have to append his signature to each entry. Now you make an entry here, then at the end he should have to give his sign. He should have to put his sign. And the date of the board resolution which is authorizing him, that should also be mentioned. See, they can, board may authorize Mr. X, then subsequently Mr. Y, in which date of the board resolution was passed, then the date of the board meeting, wherein they authorized that this person can put his signature in that register. So that date of the meeting, date of board resolution means then generally a meeting will be held. So that unless and until it is a circular resolution, generally a physical meeting will be held. So the date of board resolution authorizing the same. So wide board resolution dated, suppose if it is 28th March, 28th March 2026. So we will write it this way. So wide board resolution dated. So you are making note in the remarks section that using that Mr. X has got authority to authenticate if it is any other person. So that should also be mentioned there. Up to this, have you understood with regards to register? Shall we proceed with the next concept? Okay. Yes. Next is an interesting topic in the sense beneficial interest. What is a beneficial interest? Suppose pursuant means based on the order. See, pursuant to an order means, I think, pursuant to an order. That means an order has been passed based on that. Because the order was passed, this was done. Pursuant means since the order was passed. Because the order was passed, so they would have specified. So pursuant to an order means because of that order being passed by the competent authority, then you have to, what is the order dated? Suppose the order has been passed on 28th March. So they would have specified wide order passed, wide order dated 28/3/2026. So pursuant to an order, they are making this rectification. So pursuant to an order means wide order pass, they will make an entry. That is the thing. So I have noted your doubt. I will tell you at the appropriate time. Okay. See, No, beneficial interest. Now, every public company should have 7 members, right? Now, there are only 2 members. Then, for the namesake, because the number required is 7, they would have asked another 5 members to give their names as members. Then they are called as registered owner, but they are not the members. For namesake only, they are the registered owners in the register of members, their name will be entered. So let me write it. AB are the owners. They have requested C, D, E, F, and G to give their names as members. Now, C, D, E, F, and G, for the namesake, they have given their name. So, in the ROM, it will be shown as the members are from A to G. Their names will be written. But the reality is that they hold their shares or they have given their names for the basis of beneficial interest only. If any dividend is declared, they will not get it, only it will go to the true owners. So they are holding it for the namesake only. That is called as beneficial interest. Now, who are the two true owners? For namesake, they are giving it. Now, AB, their name might not be there or might be there, or it could be even a person X. Now, X is the true owner or X limited is the true owner. Assume X limited or X is the true owner. It could be a company or it could be an individual. So, in that case, what they would have mentioned, see, you take the name, you be the register of members, your name, you use it, but you are not the true owner. For namesake alone, for increasing the number to 7 members, they would have subscribed their names to the memorandum, but they are in effect, they don't have any interest in the company. So, registered owner. Now, should they have to declare their details? Yes, they should have to intimate that they are only beneficial owners, they are not the owners. That they should have to declare to the company. Now, X is there. Now, let me write it. Now, X name is not there in the register. C to G name is there in the register. Now, C to G, they are the registered owners, right? They have to give to the company management MGT 4. They have to file with to the company. Now, X is there. Now, his name is not there in the register of members. Not a registered holder, but he is the beneficial holder. On his behalf, C to G is there. So, but he is the beneficial owner of the shares. Then he too should have to intimate that he is the beneficial holder in MGT 5. Now they have to declare their interest. Now I repeat, C is saying, though my name is there, I am only the registered holder, but I am not holding any beneficial interest. So that should have to be declared in MGT 4 to the company. To the company only they are declaring this first. And the person who is the beneficial owner, but his name is not there in the register of members. he should also declare who's not the registered holder of that particular shares which is held by C to G. He should also declare and file MGT5 to the company. Now the company will collect these two forms, MGT4 and MGT5, and the company will file to the ROC. After getting this MGT4 and MGT5, they will file MGT6 to the ROC. In that MGT6, both these details will be incorporated, and that intimation is given to the ROC. Now, this MGT4 and MGT5 is given to the company. The company in turn intimates it to the ROC in MGT6 that these persons are the beneficial owners. Now, this tabular column will explain to you the provisions. What is it? A registered owner. Declaration in respect of beneficial interest in any share that should have to be done every year, or whenever there is a change in beneficial interest, that also should have to be declared. Now, who's declaring? Who's that person who's declaring? A person who's not holding who's the registered owner, but who does not hold beneficial interest. So in my example, we will take it as C, D, E, and F. So he is the registered owner. His name is there in the ROM. So he is the registered owner. His name will be there in register of members. Now he should have to declare MGT4 to the company within 30 days of acquiring that interest. Then every year also they will declare. So just a safeguard that there is no change. That also they will do it. Then beneficial owner who holds beneficial interest but not the registered holder. So he too will declare his interest. In our example, it is X. It could be a company, it could be an individual, whoever it is. His name is not there in the register of members. So he should have to give MGT5 to the company. He should also give within 30 days. The company, this wording is very important. On receipt of declaration by these two persons, it is only declaration with the company. So it is a proof. They are getting the proof. The company is getting the proof because they don't know what is the actual situation. Who is the shareholder's position? Who is the beneficial holder, or who is the owner? Who is the holder? They are not aware. So they get the declaration, and once both have given their declaration, then the company will process, the company will specify it to the registrar in MGT6. In MGT6, this is an important thing. It will be given to the ROC within 30 days. That is the time limit. This is the concept in beneficial interest. I'll give you a minute's time, just go through it. MGT6 is the document which is being filed with the ROC. Right. Then, what are the other points that you should have to consider? If there is any change in beneficial interest, for any change in beneficial interest, that should be reported to the company within 30 days. So every company shall designate a person. So either the company secretary or a key managerial personnel or every director, he shall be responsible in providing the information to the authorities. Yes, definitely it will be mentioned in the register of members that we will be seeing now. In the subsequent slides, I will be explaining it to you, Dhanalakshmi. They should have to maintain that beneficial interest, that register also should have to be maintained by the company. So the person who's the company secretary or the key managerial personnel or a director shall be responsible to intimate it to the authorities. And you should also mention that in the annual return, because in the annual return you will be specifying the details of the shareholders, whether any changes has taken place, that we will be learning subsequently when I talk about this annual return. So any changes made, that should also be given. If the company changes the designated person, see now the company secretary can be a designated person. Now the company secretary gets changed or another company secretary comes or they have authorized the director instead of the company secretary. Now the company has made a change in the designated person, that should be mentioned in E form GNL2, general. So the general notice should have to be given. Here afterwards, Mr. S will be the designated person. To the ROC, when the change in the designated person takes place, that should be mentioned in E form GNL2 to the ROC. Suppose the company has not filed this declaration, or when the declaration is not made by the beneficial owner, then any right shall not be enforceable. Now, it is his right, he has taken it. Then any right with respect to shares shall not be enforceable by the beneficial owner because he has failed to give the declaration. How will the company know? So the company should be given the declaration. So a person beneficial owner has failed to give the declaration, then he cannot claim any right. Say if dividend is declared, it will go to the registered owner. That is the concept. Then exemption. Is every company should have to do it? No, there is an exemption. Rule 9 that does not apply to a trust which is created to set up a mutual fund or a venture capital fund or other fund authorized by SEBI. So that is an only exemption. This may be asked in MCQs. The peculiarities could be tested in MCQs. Which of the following, I can ask the question, which of the following is applicable? Mutual fund, venture capital fund, then both the above, none of the above. So exemption is available to first one, mutual fund, second one, venture capital fund, third one, any fund approved by SEBI, fourth one, all of the above. If I ask this MCQ, then your answer should be all of the above. Then if I twist the question, exemption is available to mutual fund, second one venture capital fund, both 1 and 2. Fourth option, neither 1 nor 2. Or I can give none of the above. Exemption is available to. In this case, what will be your answer? If I ask this question, if this is your MCQ, how you should have to answer this? Yes. So 3 is the answer. Both 1 and 2. That is the answer. Good. So I can twist the question. So when you read it, what I used to do is that it is likely MCQ. I will make a note in my material, likely MCQ. I will make a note and I will read that separately. You should have to mark this like that when in your study material. So you have to read it. I will tell you another thing. Certain topics which you find it difficult, you want to go through it before the examination. In that study material itself, in the last page, you make a note to be read before examination. You write a note there in the last page of the study material. See, one thing is that if a student is very confident, he will do that answer correctly any number of times. Suppose it is a problematic or confusing topic. All the confusing topic or where it might be for you, it might be a difficult topic or what you feel that you are not having a hold on that topic. You find that you are again and again repeating your mistakes. That you can note the page number in the study material. So say it is 7.15, some number is there. So you should have to go through this and before the examination, you should have to read it, pay attention to it and read it separately. You should have to go to this, you should have to read it. Then similarly, you find out what are, you identify for you what is the problematic topic or you find not comfortable, you are not confident. So those topics, if you list it, so on the day before the examination, you will be reading only those particular topics again and again, and you will see to it that you are not making any mistake in the examination. That at the time of reading itself, you should have to turn to that last page in that study material. You make a note to be read before the examination. At one particular place, you make a note there. So, what are the page numbers or the topic? Or if you don't want to write the topic, at least the page numbers you write it. That is easier for you, no? So you can refer that before the examination once, twice, 1 week before you can, at the time of revision, that you can do it. So this is one way of reading. Then penalty for non-compliance. Now, two sections talk about the penalty. 89.5 and 89.7. What is the difference? If the person fails to give a declaration, that is 89.5. If a person fails to make a declaration, then the penalty is 50,000 rupees. Then for continuing default, it is 200 per day. Maximum is 5 lakh rupees. Then 89.7, when the company fails to file the return, the company and every officer in default is subject to a penalty because they have delayed. So 1,000 per day. There is no fixed penalty. It is only a continuing offense. So 1,000 per day, subject to a maximum of 2 lakhs for officer and 5 lakhs for the company. This is the penalty for non-compliance. If the company has not complied with the provisions, then it should have to pay the penalty. So this chart will give you a clarity. Nature of default, it is not who's the person not making the declaration, namely the registered owner and the beneficial owner not making the declaration, then they are subject to a penalty. Initial penalty is 50,000 and for continuing default it is 200 per day, subject to a maximum of 5 lakhs rupees. So the company has made a default in filing the return. It has not filed the return. It becomes a continuing offense and it is subject to a penalty of 1,000 per day and the maximum is 5 lakhs for the company and 2 lakhs for offices. Yes, penalties they can test you, but it is a memory oriented thing. I do agree, but one or two questions will be asked in penalties. You should have to at least remember that it is a continuing offense. What is the penalty? So, what I would suggest, penalties alone, you should have to read it separately. So, in which chapter, what is the penalty? You have to prepare a chart and you have to read it. That way, we will have it. Shall we continue or shall we have a break? What is your mindset that? Yes, we will have a short break for 10 minutes and then we will meet. So we will have a 10 Okay. So
Excuse
we
me,
have,
ma'am.
yes.
Ma'am, I have one doubt. Ma'am, in order to comply with the Companies Act, the concept of that registered owner is into the picture,
Mm.
right?
Mm.
What's the need of penalty, penalizing them for not filing the declaration?
See, the act is specifying that whatever is there, then you are not showing the true situation, right? So for that, penalty is given. See, the company should have to give a
Okay,
true
ma'am.
situation. So for that, the act specifies that. See, one thing, unless and until a penalty is levied, we will not take any steps into complying with the situation, yes or no. See,
Yes,
you are
ma'am.
not supposed to cross the line. Nobody is hurt, but still, why they are levying a penalty? Because only if they levy a penalty, the riders will not cross that particular line. Right? Penalty is penalizing in nature. There need not be actual loss, but still, if this penalty is not levied, they will not comply. So for that reason only we
Okay.
keep a penalty in company law. So automatically they will know, they will ask
Okay.
the person to give the declaration. Hey, penalty is there. You give the declaration. Otherwise you have to pay penalty. Then you won't delay in giving the details. So the company is in turn facing the consequence. See, it
Okay,
is
ma'am.
1,000 per day. Suppose there is a delay of 50 days, assume. So 50,000 rupees gone for delay in filing the declaration. So the reason for penalty is they
Okay.
want the company or the persons to comply with the provisions. That is the reason. Then there is something called
Ma'am,
as
beneficial owners should pull them, right? Because they are not going to dividend. Registered owners will not get any dividend or anything. Beneficial owners should pull them, right?
no, registered owners. The company will know only about registered owners because their name is entered in the register of members. So
Okay,
they
okay,
will
ma'am.
make a declaration, it should not belong to me. Though I am the registered owner, the dividend should go ultimately to the beneficial owner. So that declaration is given by the registered owner. See, registered owners are
Okay.
the name whose name will be entered in our register of members. That's why it is registered. Registered means their name is there in ROM. See, in
Yeah,
register
ma'am.
of members, you will have only registered owners. Why they are called as registered owners? Their name is registered in the register. So they are called as registered owners whose name is entered
Yeah, ma'am. Ma'am, I
in.
have one more query actually.
Yes.
Company can maintain wherever they want in India if 1/10 of the members are
Hmm.
situated in that place, right?
Yes. Yes.
What if what a key person who is holding the key portion of a shareholding
Hmm.
demands that he needs to maintain demands to maintain the register of members in that particular place instead of that 1/10 of members. uh, is this scenario possible, ma'am?
Yes, if he holds 1/10 of the share capital, see what is that? 1/10 of the total members. It is not specifying 1/10 of the share total members entered. So 1/10 of the total members entered in the register of members reside. It's not saying 1/10 of the share capital. The wordings are very important.
Okay, ma'am.
See, the
Only
members might
one
be.
alternate
I will tell you
is
what is the
possible, right?
difference.
Okay.
One difference, what is there, I will tell you. See, a person, you can have a register of members, say, for example, I'll write it here. See, there might be 40 members.
Okay, ma'am.
So they might be holding, one member might be holding 50 shares, another person might be holding 500, another person might be holding 5,000, another person might be holding 50,000 shares. Now it is saying 1/10 of the total members. See, one member share, you will have it, he will have only one registered folio. Irrespective
Yeah,
of the number of shares he has held, he will have only one
okay.
folio in the register of members.
Okay, ma'am. Okay.
Right? So a separate name will be allocated to him. Say A, B, C. Suppose there are 26 shareholder, 26 members. So A to Z are the members there. So the 26 folio will be created. Right? So
Okay,
A
ma'am.
might be holding 50 shares, Z might be holding 5 lakh shares. So 1/10 of the total members entered in the register of members. The, in which more than 1/10 of the total members entered in the register of members reside. The company pass a resolution to that effect. Yes, when there is no objection, even the others may give a no objection. Then, if the shareholders pass the resolution, then it is register of members to be there. Yes, but they have to give the arbos.
Okay, ma'am.
That says other than which more than 1/10 of the total members entered in the register of members reside. So in that
Okay.
place you can have the register of. There are companies for practical. So in practical, if they have, sometimes the members may ask, no, we want the thing to, we have, there are practical instances where listed companies or any company who wants to maintain at a place at a registered office, we have filed forms for it, and it should have to be, resolution should have to be passed. If special resolution, automatically that filing of the form should have to be the ROC. That a special resolution has been passed, you have to intimate it to the ROC. So you have to file the form. What is the special resolution? You have to attach the extract, where, in which meeting that special resolution, whether it is an annual general meeting or a general meeting. So everything we should have to attach it with the form, and you should have to intimate it to the ROs for any special resolution passed by the company. Now we shall proceed further. There is something called as significant beneficial owners reporting. This is basically some rules which students invariably neglect. So we will quickly go through what are all the rules in a short format. We are not going in detail. I've just collected the gist of it and I have put it in the slide. So significant beneficial owner, SBO, we call it as. Now, you have to identify who's a significant beneficial owner and you have to report that. So SBOs are individuals holding more than 25% beneficial interest or exercising significant influence or control. And if they hold more than, SBOs include those with more than 10% indirect or direct shareholding. So there the percentage is more than 10% if they hold it through another person. Say it could be a holding company or a subsidiary company, not a direct shareholding, but an indirect way of participation, then that also should have to be mentioned. What is significant influence? So, power to participate in the financial or operational decisions without control. So, they are participating without control. So, that you should have to mention it. And should this interest be declared? Yes. it is a beneficial interest. So BEN stands for beneficial interest. If the company has beneficial interest
Ma'am,
shareholding, then that company is liable to declare, not every company.
ma'am,
Only
your
if you
PPT
have
is
this,
it is
pardon?
not displayed. PPT is not displayed, ma'am.
Pardon? Screen is not visible. Just a
Yes, yes.
minute.
Yes.
So you have to file only for the companies who have this beneficial interest. They have to file Ben 4, BEN 4, form Ben 4 to the registrar of companies. And they maintain that register. That register is, somebody asked, will they maintain the beneficial interest register also? Yes, the format is BEN 3 is the form in which it is there, and it is subject to inspection. For non-compliance, it includes fines and legal action also. So the company should have to notify that SBOs, significant beneficial owners, and they should have to file this declaration within the prescribed time. Form B and 4 should have to be declared. They, sum and substance of that is that, this slide is that B and 3 format register. Then they have to file B and 4 form to the ROC. So when they have this company which has got this significant beneficial owner, they should have to report it. That is the concept. Then application to tribunal for share restrictions. Then a company may apply to the tribunal. The process involves applying to the tribunal within 15 days to seek restrictions on shares. If they want to apply for share restrictions for transfer or any restriction, if they want to have, then an application should be filed within 15 days of notice expiry, and the tribunal may impose restrictions on transfer. It may suspend the rights. If there is any dispute, they can apply to the tribunal and prescribe the other matters. Now, what is the restriction? That restriction includes that interest or dividend should not be transferred. Voting rights is not there. So, if there is any issue involved, that should have to be specified. And Section 98 of the Companies Act allows the tribunal to restrict rights within 60 days of the application, and the aggrieved person can seek relaxation within 1 year. If no application is made, so generally what happens if the dividend is unclaimed, after 7 years it will be transferred to IEPF, Investor Education and Protection Fund. Similarly, if no application is made within 1 year, there is no thing, then it will be transferred to Investor IEPF account, Investor Education and Protection Fund. It will be there. The dividend or interest, whatever is there, it will not go to the shareholders, but instead it will be transferred to IEPF. So the tribunal has got the right to relax the application or lift any restriction. Then declaration of beneficial ownership. Declaration and filing of significant beneficial ownership. See, the SBOs should have to declare their holdings in BEN 1. Then the company will report to the registrar in BEN 2, BEN 2 within 30 days. Generally, 30 days is the time limit. So it was started from 8 to 2019. So initially they have filed it within 90 days from 8 to 2019. The significant beneficial owner should have to declare that they are the significant beneficial owner to the in form number BEN1 within 90 days. Then within 30 days of receiving the declaration, the company should have to file the declaration. Then any change that should be declared within 30 days. But this SBO rules is not applicable to certain authorities. See, in question number 9 in your self-examination question, in your material, there is a separate question. I think it's 7, question number 7 or 9, I'm not sure. So there is a separate question in your material. What are the exemptions or where SBO rules is not applicable? So they would have mentioned that in points. So it is not applicable to the following entities, and they would have specified that. So what are they? To whom it is not applicable? To the Investor Education Protection Fund Authority. So IEPF, it is not applicable. Or to any holding reporting company of that company. So for them also it is not applicable. If it is a central government or a state government or a local authority, it is not applicable. Then it is for a SEBI registered investment vehicles like mutual fund or venture capital fund, if it is registered, or any other fund registered by SEBI, or if that investment fund is registered with RBI, then insurance regulatory authority, or pension fund regulatory and development authority. So in all these cases, this SBO rules is not applicable. For others only it is applicable. So this is a specific exemption given. So this will be tested. So there is a separate question there. So this you should have to remember. It is not applicable to certain entities, like this can be tested, or they can ask you an MCQ also in this. MCQ or a descriptive question to test whether to whom it is not applicable. So this you should have to concentrate it, but students invariably don't go through it. So that you should have to make a note. Then what is the penalty for contravening the provisions? See, 9010 talks about for the SBO if it is an individual. Then 11, both are the same. 9011. Both are specified in 9011, section 9011. Section 9010 is for the individual. So it is initial penalty is 50,000, and for continuing failure it is 1,000 per day. If I say 1,000 for continuing failure, that is per day it is 1,000. Maximum limit subject, it is capped at 2 lakhs for the individual, and for that officer it is 1 lakh. A big paragraph is there in your material. So that can be condensed in one tabular form like this. If you read this with your material, it will be easier for you to understand. So that I have condensed this in a short thing and I have given. So this 9011, so 11 subsection 11 of 90 section 90 talks about both company and the officer. So for both, the penalty has been provided. So for the company, it is 500 per day. For continuing default, it is for officer, it is 200 per day, and it is capped at 5 lakhs for company. Generally, the company will get the maximum penalty. So any contravention is also compoundable. You make an application. I will tell you what it is. For the time being, you say that it is You make an application for compounding of offense. It was not willful. You ask, you make an application to the authority and say that please compound the offense. It is not. Compounding means you are asking, waiving the imprisonment and asking him to do it with fine alone. So they should not imprison you, and you are making an application that it was done inadvertently, it was neither willful nor deliberate, kindly condone and treat it, compound the offense, and so that your imprisonment can be avoided. That is the concept here. So penalty alone is leviable. Then. This is a very interesting thing. So you are keeping that register of members. Any register of members, the rule says you can close the register of members. But at the stretch, you can close it for 30 days. Maximum time period in a year is for in aggregate it can be closed for 45 days. A company generally before the meeting it might close, say for 25 days it can close. Then it can close before the general meeting for another 10 days. And before another general meeting it may close for another 7 days. But totally put together, it should not be greater than 45 days in a year. At a stretch, a company cannot close the register for 31 days. That is not possible. See, closing of register means it is not subject to any inspection or that the company wants to make entry. So before the general meeting, in the notice you will find, I will show that. In the notice you will find the register of members will be closed from, they will give an intimation, will be closed from say 1/9/2026 to 10/9/2026, both days inclusive. You will find it in the notice that in that notice they will mention what are all the days in which the register of members will be closed. That is during that time, whatever, if they have any transfer is made or that will not be affected. See, if you want to declare a dividend, the company wants to declare a dividend, they should have to hold a record date. What is that record date? Suppose 31st March has been declared as the record date. Assume. If you want to do the transfer, you should have to effect it before that. Then after that, the register will be closed. They will take only this as the cutoff point. So when it is closed, you cannot make any entries when the register is closed. So the company will not make any entries in that register when the time it is closed. So they will intimate it to the shareholders that the register will be closed from this date to this date, 4 days inclusive. That will, you will find it in that notice. They will put the additional points. First point, second point, third, fourth, like that they will mention. In that it will be mentioned. You can download any copy of the notice and you will find if they have mentioned it, it will be mentioned in that notice. So it will be intimated to the shareholders that the register of members will be closed. To find out, to ascertain who are all the persons who are eligible for that dividend. It could be any reason for their activity, they can close the register of members. For that, the company should give at least 7 days prior notice. Prior notice. So before closing, you should have to give the notice, not after closing. That is the meaning of prior notice. If you give 7 days, if you write 7 days notice, your answer is not complete. The answer is at least means minimum 7 days prior notice. That is, before closing the register of members, it should have to intimate it to the shareholders that the register will be closed. 7 days. So, 1st September, I am going to close. I can give it on August. Say on or before, I can give it on 1st August that the register of members will be closed from 1/9 to 10/9, or it should be at least 7 days. 7 days before I should have to give the notice. That is the concept. Listed company should have to give their advertisement in 2 newspapers. One in vernacular, one in English. Vernacular means whatever is the language in that area. Suppose it is Punjab. Punjabi is a vernacular language. Maharashtra, Marathi, or Orissa, so Oriya. So that is the local language that you call it as a vernacular language, and one in English language. In 2 newspapers, you should have to give the advertisement for a listed company. And also, when the government has notified, you should have to specify in that particular website and the company website. You have to mention. Then at a stretch, it is only 30 days is possible. You cannot close for 31 days. I cannot say from 1st September to 2nd October, the register will be closed. I cannot say. Then 45 days in an aggregators, it should not exceed in a year more than 45 days. Suppose a person has not fulfilled this or he has contravened this provision, whether without giving notice he has closed or short notice, 3 days notice he has given and closed, then the penalty is 5,000 rupees per day, subject to a maximum of 1 lakh. So the law is strict. Suppose you have given short notice means no notice, whether no notice has been given, that is without giving notice. Short notice means any notice less than 7 days is considered as a short notice. Say 3 days notice or 5 days notice, that is a short notice. For that, the company and officer in default, both are liable to penalty of 5,000 per day. But of course, the maximum, if it exceeds, if you get the penalty as 1.5 lakhs, they continue, they have not mentioned it. The maximum is only 1 lakh. So it is capped at 1 lakh. Again, it is a compoundable offense. They can make an application asking them to do it with penalty alone. That is an application should have to be made to the respective authorities. Have you understood up to this? A quick recap of what we learned. Yes. So in today's topic, we talked about registers is important. So excuse me. So the first part alone is today's discussion. We have to go through this annual return and a meeting, all are practical applications. We will see one by one. You maintain a register of members in MGT 1. It is management, right? Management and administration. So the form is MGT. CHG is for charge, MGT is for management. Then accounts of companies, AOC. Like that you have the first 3 letters is the expansion of that denotes what the form pertains to. So MGT. So we are talking about management and administration. You should have to be thorough with MGT 1. This is for register of members. And MGT 2 is the register that is maintained for debenture holders. And you maintain the index. If it is more than 50 members are there, you maintain the register. Then foreign register, you maintain it in MGT 3. And MGT 4, 5 and 6. So MGT 4, we saw that the members, the registered owners and the beneficial owners, they declare it to the company in MGT 4 and 5, and company give the form or file the form to ROC in MGT 6. So 1, 2, 3, 4, 5, 6. So here questions can be asked. MCQs can be asked. Which is the form? What is MGT 4? What is MGT 5? What is MGT 6? There you should have to concentrate. Then register, you maintain a separate register for significant beneficial owners. For SBO also you maintain the register. And you can close the register of members or debenture holders. The rule is that at a stretch or at a time, not more than 30 days. At one time. That is the meaning. And not more than 45 days in aggregate. Aggregate means in 1 year. The maximum time period to close register of members is 45 days. Then what is the procedure for closing the register of members, debenture holders and other security holders? That is ROM, a register of debenture holders, OSH, other security holders. That they have mentioned it in Rule 10. So you have got subsection 1, 2, 3, 4, 5. You have got 88 talks about register of members. Then we saw the register of members should be maintained for each class. For preference shares, separate register, separate thing. You have to maintain it separately. Then equity shareholders, even in equity shares, there will be rupee 5 paid up, rupee 10 paid up, rupee 100 paid up. They will have a different class of equity shares. So each one is a separate thing, right? Because the names might be different. So it could be rupee 10 fully paid up. It could be rupee 100 fully paid up. This is one class of equity share. This is another class of equity shares. So that's why they have specified each class of equity and preference shares. There could be a 9% preference shares or there could be 12% preference shares. I'm just giving you an example. So that will be mentioned in the liability side of the balance sheet separately. So 9% preference share capital, 12% preference share capital. And so many classes are there, so many register of members should have to be maintained. As simple as that. If I want to check what is the balance sheet, how many class of equity shares, preference shares, if it has debentures, then it should have to maintain a register of debenture holders also. So that many number of shares or that many number of class of shares, then the company should have to maintain that many number of register of members. That is holding of each class. It should have to maintain separately. That is the concept. Shall be shown separately in the register. And MGT1 is the format. And what is the name, address, email address, permanent account number, or a corporate identity number. Even a company could be a member. So in which case you should have to give the corporate identity. If it is an Indian company, you can give the corporate identity. of that holding company or a subsidiary company, whatever it is, that CIN should have to be mentioned. Then for debenture holders, it should be in form MGT2. For each type of debentures, you have to maintain a separate register. The event is after allotting the debentures, you should have to maintain it. Suppose the company has allotted 9% debentures first. See, debentures are redeemable, right? When it comes to debentures, it is not permanent, it is redeemable. The redemption of debentures are there. Then when they issue new type of debentures, then again they have to maintain it in MGT2. That next set of debentures should have to be maintained in MGT2. That is the thing. So whenever they issue or allot the debentures, then they have to maintain. And the time limit, it is 7 days. They have to, excuse me, within 7 days of approval by the board or the committee, they should have to enter it in the register. And where it has to be maintained, generally it is maintained at the registered office, but by special resolution passed by more than 1/10 of the total members by a special resolution, then it can be maintained at some other place also. Then whatever, if they have created a promoters have created a lien, or they have got pledged it and they have obtained the loan, that also should have to be specified in the register. Or joint venture interest, that also should have to be mentioned. Yes, whether it is listed or unlisted, they should have to specify that in the register. It is better to register. Generally, it is advisable. So what we used to advise is that the company should not face any consequences for not complying with the provisions. That is there. So any rectification in the register can be done. You have to maintain an index when it is more than 50 or more. See, you have to write it when the number of members is less than 50, it is not necessary. Less than 50 means 49, it is not necessary. 50 means it is necessary. That is the meaning. You should have to read it correctly. Whether it is less than 50. See, 49 is less than 50. 50 means it is not less than 50. It is equal to. So 50 or more, you should have to maintain an index. So in law, you should have to read these points very carefully, understand it very carefully. Understand it correctly. Less than 50 only, it is not necessary. So 49, it is not necessary. Then when they keep the foreign register, they should have to follow the procedure. It is optional, but if they maintain, they should have to follow the rules. That is the concept. They should have to make entries. And beneficial interest, MGT4 by the registered owner, this you should have to remember. So which form, who files it? MGT4 by the registered owner. So registered owner, MGT4, the beneficial owner, MGT5. Put together, they will collect it. The company will collect these forms and then they will file with the ROC in MGT6. Only after, on receipt of declaration only it can file. Before receiving, it cannot file. That is the concept. Within 30 days, you should have to file it. And any change in the designated authority, that should have to be filed by the company in GNL2, general. So GNL stands for general. And it is not applicable for a mutual fund or a venture capital fund or a SEBI approved fund, it is not applicable. Then penalty, you can just go through it. You have a significant beneficial owner and BEN1, they have to declare their holdings in BEN1 and the reporting company files BEN2 within 30 days of receiving the declaration. And it is not applicable to certain entities like in IEPF or SEBI invested registered investment vehicles or RBI, IRDA or PF Regulatory and Development Authority. It was contravention, it is there. Closure of register of members, 30 days at a stretch, maximum is 30 days. At a stretch, it could be lesser. Nobody is going to question you, but it should not exceed the maximum time limit or maximum days. You cannot close the register for 31 days. You cannot similarly close the register for 46 days in a year. Maximum time period is only 45 days. That is the concept. We will see one by one the MCQs. See, when it is with regards to penalty, you should have to prepare a chart and you should have to do it. So because one of the students asked, yes, it is a memory technique. You should have to, as a student, it is expected. A person fails to make a declaration of beneficial interest under 89(1). The failure continues for 300 days. So even before I complete it. Now the question is, see why I gave this MCQ is that the question is not asking you to calculate the thing. The question is, what is the maximum penalty? See, this is the crux. He is not asking you to calculate for per day how many things, like what is the maximum penalty? It cannot go beyond it. Not go beyond this amount. What is this amount? That is the question. See, students invariably don't read the question carefully, right? So many have given the correct answer. So the maximum is 5 lakhs. You will calculate 1 lakh 10. So 50,000 plus 200 per day into, you will calculate all these things. But the question is, what is the maximum? Maximum is only 5 lakhs. So answer C is the correct answer. So C is the correct answer. See, why I gave you this thing is that you have to read the question carefully in MCQ. Students go wrong because of not reading the question. See, you have a preset notion. You think that it is tested only on that. You start writing the answer. There is the problem. So there you should have to pass what is the question. Similarly, you find even if when the question for descriptive answers are asked, the question might be one thing, but you are writing the answer differently. See, read the question. If they ask you define, you have to write the definition. What do you understand by? You should have to read the question carefully. Then it is different. Then discuss, examine. Examine is you have to write both the pros and the cons, advantages, disadvantages. Whatever you know, you should have to write. And advise. Discuss, analyze, and advise. So, when this advice they have given, you have to write your conclusion. What is your advice? For that, marks will be given. So you should have to write what is your advice. So it is very important to read the question carefully. Right? What is asked? What are the provisions? Illustrate. Illustrate means you have to write it with examples. So you have to read the question. List. List means you have to write 1, 2, 3, whatever the points. What are the steps or stages? Then order should have to be followed. You cannot change the order. See, how do you take the steps? First, second, third, fourth, fifth. So steps are stages. You cannot write the third point first and then first point second or this. The order should have to be followed correctly. So this you should have to concentrate, go through the suggested answers, and or your RTPs, your model test papers are there. So go through that, how a question has been answered, that you should have to go through it. While reading, you should have to concentrate on all these points. That you should have to, then how the same question, the answers you should have to write it differently. The points might be the same, but you are asked to give, explain with the help of a decided case law, then you should have to give the name of the case. So you should have to read the question carefully. That is more important. Then, next MCQ. XYZ failed to file return of beneficial interest, MGT6 for 400 days. Compute the penalty for the company. So the company has not filed it with the ROC. They should have to collect MGT 4 and 5 and they should have to file MGT 6. Refer and tell me what should be the answer. See the penalty, you have to compute. Here he is asking you to compute the penalty. Suppose if the penalty exceeds the maximum limit, then the maximum amount will be the penalty. If it is lesser than the max, then you should have to give the actual penalty. That is the meaning. So for questions of this sort, what is the concept? Suppose you have calculated the penalty. If the calculated penalty exceeds the maximum penalty, it is maximum penalty. It cannot go beyond the maximum penalty. If it is lesser than the maximum penalty, then this value will be the penalty. Whatever you have calculated, that will be the penalty. That is the concept that you should have to understand. I get different answers. Okay. Let us see the answer. More. A is the answer. So maximum limit is not reached. So 1000 per day for 400 days. So it is only 4 lakhs. So A is the answer. Because maximum limit is not reached. That is the explanation. Register of members must be maintained by only public companies, only companies with share capital, all companies, only listed companies. Whenever you get this word only, you should have to read it carefully. In the material or everywhere, you get this word only, alone. These are to be read with caution. So many have given it correctly. What happened to unlisted companies? Is there any exemption to them? No. Every company should have to maintain. See, every company. See, only companies with share capital, no. Even companies without share capital, they should have to maintain the register of members. So all companies is the answer. All companies. Private limited company or public limited company or companies with share capital, without share capital, in every company should have to maintain the register of members. You have register of preference shares, even you have register of debenture holders. You have to, when you are maintaining that, what about members? That is very important. A private company closes register without newspaper advertisement but gives 7 days notice to members. Is it valid? You are giving the answer invalid, valid, valid only if approved by ROC, invalid unless special resolution is passed. What is the provision of this act? That you should have to be thorough. I get mixed answers for this particular MCQ. See, private company, it is enough if they give 7 days notice alone. Have they mentioned it as newspaper advertisement? No, 7 days notice alone is prior notice. 7 days prior notice is essential. So it is enough. See, what is the concept? See, for a private company, it is closely held company. You cannot invite the public to subscribe. See, what is a private company? Only your friends and relatives will be the members, right? So for that, the rule, it is a small company. The compliance is also very small it is comparatively less, not small. It is less for a private limited company. Compared to public limited company and listed company, for a private company, it is enough if it gives 7 days notice to members. It need not give a newspaper advertisement. So it is perfectly valid, at least 7 days notice. So 7 days prior notice should have to be given. See that. I'll go to that particular slide. And I said closure of register of members, right? Closure of register of members. Listed company should give advertisement in two newspapers. I said one in vernacular and one in English. So only for a listed company it is there. Companies can close provided the following conditions are fulfilled. At least 7 days prior notice. So only listed companies. So here that listed companies. Only listed companies should have to give advertisement in two newspapers. And it should also notify in government notified website or a company's website in case of a listed company. So that rule is applicable only for a listed company. For a private company, it is not applicable. So it can close provided it gives a 7 days prior notice. That is the concept. So make a note of the mistake, rectify it. Then Company registers for closes register for 50 days. What will be the penalty? What is the rule? What is the provision at the maximum time limit which it can close is only 45 days in aggregate. And that too with a rule that not more than 30 days at a stretch or at one point of time. So this is the rule. So try to understand the rule whenever there is an MCQ asked. What is the provision that you go through it? So it is 5,000 per day subject to 1 lakh. So the first option is correct. Now you go through the provision, closure. It is, I have specified, company and every officer and default penalty 5,000 rupees per day, maximum 1 lakh. So in this I have asked the MCQ. Then Mr. A registered owner and Mr. B beneficial owner both failed to file declaration under section 89. Who is responsible? Who is liable? So A is the registered owner. B is the beneficial owner. The rule is that they both should give the declaration to the company and the company will give it to ROC. So what is your answer? Yes, many have done it correctly. Both A and B are responsible for the penalty. So C. So both fail to give the declaration. So both A and B are responsible for that. So any doubts? If there is listed company, then there is violation. Instead of private limited company, if the listed company has failed to give the advertisement before closing the register of members, then there is violation. Then the company is responsible. It is not valid. That is the concept. So I have covered the first two things. In the forthcoming classes. We will concentrate more. It will be very interesting. All the practical aspects we will see. Okay. In question 4, what is that in question 4? See, question 4, it is the private company closes register without newspaper advertisement. Is it valid? Suppose if I have asked listed company, if I have given listed company, then the answer will be different. It is not valid, right? So since it is a private company, for a private company, it is enough if 7 days notice is given. For a listed company, they should have to give in two newspapers, one in vernacular newspaper circulating in the state in which the registered office is situated, and one in English newspaper, at least two newspapers. And they should also give a 7 days prior notice. That is important. And you are asking me about significant beneficial owner, SBO, that I will explain once again. See, significant beneficial owner, if they have, they could be individuals, they could be company, they could be an any person or any other organization also. So what they say is that if they are individuals, if they hold more than 25% beneficial interest, then they should have to declare their interest. And it also includes more than 10% of indirect or direct shareholding through someone you hold. It could be a holding and subsidiary company. So together they hold. It is an indirect holding. It could be a trust. It could be, of course, that significant beneficial owners is a separate topic by itself. But you have got only the condensed version in this room. It could be a trust. It could be an HUF. It could be anything. So for HUF, the Karta is the person who's holding it. So he is holding on behalf of the HUF. So it could be a direct or an indirect shareholding or the voting rights. So when they participate, when they hold it, they become the significant beneficial owners. The percentage is given in the act. That is that. See, you're joining together and you're holding that interest. So that is called as you're combining yourself. See, it could be held by a company or a HUF or a trust. The company itself might have a trust. The company and the trust may do it. So that is, you call it as pooling of interest. So put together, it is 25%, holding more than 25%, and here it is more than or equal to 10% of interest that they should have to specify their ownership. So they are the significant. Significant means majority or they hold 10% or 25%. For individuals holding more than 25%, for others it is 10% indirect shareholding that they should have to report. That alone you remember, you write it. Is this clear? Hope your doubts are solved. Yes. So we will meet in the next class with another interesting topic in the same chapter, management and administration. Until then, it's bye. Thank you all, and we will wind off the session. Yes, welcome everyone.